Welcome back to the channel and thank you for watching. So in this video, and perhaps in a few videos, I'm going to talk about why permission to appeal was refused and dissect those arguments and explain the process, the procedure, the relevant arguments, and ultimately why now I believe this really should be looked at again. Hence, you will have probably no doubt seen my petition to reopen the appeal, which is quite a rare process in the United Kingdom. But the provision is there in the rules for a reason. And I believe, and I humbly suggest, it is times like this where we now have a unanimous jury verdict which flies in the face of the judgment in the UK trial, and for which permission to appeal was refused. So I thought I would do this in a number of ways, but firstly by broadly explaining the procedure for permission to appeal and then the appeal, and look at some of those documents and some of the underlying evidence and the arguments that were raised as grounds of appeal, which is part of what I will explain in these videos. So first of all, looking at the grounds of appeal. Now, when an appeal is brought or application for permission to appeal is brought, ultimately you need grounds of appeal. The grounds of appeal are not necessarily the arguments themselves or the evidence itself, but the grounds of appeal you can think of as the reasons, the reason that an appeal should be granted. This might be an error of law, it might be an error of procedure, it may be, in rare cases, that the judgment was plainly wrong. And that is something that's going to feature in these grounds of appeal and in the skeleton argument, which I'm going to come back to in a moment, and particularly in light of the jury verdict in the Virginia trial, because ultimately that, as I've suggested many times, had the proper effective opponent, which was Amber Heard, which featured centrally with Johnny Depp in the UK trial, even though she was not a party to the proceedings and thus not a party, not subject to the same disclosure obligations, and even in the judge's own words, could ultimately choose what evidence she provided. So looking at these grounds of appeal here, you can see at the outset of this grounds of appeal document that it describes the nature of the appeal. Now, this is not entirely unusual to include, but it is certainly something where the nature of the appeal needs to be explained somewhat for the appellate court to consider when considering the overall grounds of appeal and then looking further at the skeleton argument. Just turning briefly to the skeleton argument so you know what that is and what it looks like and what it's for. The skeleton argument will contain the actual arguments which underpin the grounds of appeal. And there is a skeleton argument for the appellant, which in this case is, of course, Johnny Depp, and the respondents, which, of course, in this case are the newspaper and Dan Wootton. So we'll come back to this document, but this document contains the arguments in skeletal form that will underpin the grounds of appeal. The grounds of appeal being the overriding reasons that it was argued that appeal, or at the very least permission to appeal at this stage, should be granted. And if permission to appeal was granted, then the argument, as you'll see later, looked to set aside the judgment and order a retrial. So looking at this nature of appeal and why this is so significant in this particular case, because this nature of appeal and the wonderful way that it's been drafted makes clear to anyone that's reading it, and would have made it clear to the appellate court, why this appeal was to be brought. And so it states here, the appellant seeks permission to appeal, and if granted, to set aside the decision of Mr. Justice Nicol, the trial judge, finding that the respondents had proved the defamatory allegations they published were substantially true. It is recognised that the appellate court will be slow to set aside a trial judgment with findings of fact because of the greater ability with which the trial judge usually has to assess witnesses whose evidence they are based on. Now, you will remember I've said previously that appeals and permission to appeal are rarely successful, and in certainly virtually all of the cases I've dealt with have been refused. I have been successful on occasion, but it is the exception rather than the rule. And typically this is because, as this nature just outlined, the trial judge is ordinarily best placed to hear the evidence, assess credibility, and make findings of fact based on evidence and based on credibility. And both of those are important, extremely important, owing to reasons that will become clear throughout this ground of appeal and in the skeleton argument. So let's move back now to the grounds of appeal. So the outline for this nature is that the judgment is plainly wrong and the consequential decision in favour of the respondent is manifestly unsafe. And there are two broad reasons given for this in this grounds of appeal. A, the trial judge's findings were not conclusions based on or supported by carefully weighed and reasoned analysis of the evidence or the credibility of the various witnesses, but rather bare assertions without any real explanation for how he reached these serious findings in the face of conflicting accounts of events. Now, two things there. First of all, a judge should always weigh evidence and give a fully reasoned analysis of the evidence. And you will have remembered from some of my previous videos that there were inferences drawn and assumptions made. I'll give you an example. If somebody turns up to your house head to toe covered in water, dripping wet, you can make an inference and or an assumption that it's raining, they've been in a river, they've been pushed in a lake, pushed in a swimming pool. You can make any of these inferences and assumptions yourself. None of them are based on evidence. None of them are reasoned by way of evidence and drawn as a conclusion on evidence that you've received. If, however, the person that turns up told you that they were pushed in the lake, and you have another independent witness who says they were pushed in the lake, and maybe even you've got CCTV evidence that shows them being pushed into the lake, and your conclusion drawn is that they were pushed into a lake, the fact that they turned up dripping wet then does not stand on its own. You've got significant evidence upon which to base your conclusion that they were pushed into a lake. But you can see how without that evidence of either witness, CCTV and so on, you can see how there's an inference drawn and an assumption made which could be wrong. You could assume that they jumped into a swimming pool of their own accord, whereas in fact they might have been pushed into a lake. Now I'm making an exaggerated example here, but you can see that it must be based on careful analysis of the evidence and reasoned findings. The second point within this first point is that of credibility of the various witnesses, of course including Amber Heard, who was just a witness, which in itself sounds absurd because, as I said, this centered around her and Johnny Depp, and ultimately she was quote unquote an independent witness to the case. And instead of giving careful reasoned analysis as to the credibility, bare assertions have been made without real explanation of how they've been reached, and this was one of the primary points relied on in the nature of this ground of appeal. So moving to the second point referred in this paragraph, B, that he uncritically accepted at the outset that the complainant must have been correct in her allegations, and having done so discounted or ignored any evidence to the contrary, despite the fact that it undermined her credibility and the account she had given. And again, as I've said in previous videos, there were a number of occasions where her credibility and bare assumption that her allegations were true and ignoring evidence that contradicted it, ultimately, in my view, just could not have borne true. And ultimately, as I said on many occasions, undermined her own credibility and undermined the account that she herself had given in that trial. Moving back to the grounds of appeal then, next paragraph. Despite its length, the judgment lacks both analysis and reasoning for the trial judge's decisions to exclude matters which were damaging to or inconsistent with the evidence of the witness on whose veracity or reliability of the respondent's entire case depended, in other words, Amber Heard, or as to why he made findings of fact he did, as to what he said happened. And there are some very important and very serious examples of this, one of which I'm going to jump to because this will sort of give you a heads up and an idea as to what we're going to look at later, which will be very interesting. So I'm going to jump first of all to one of the paragraphs in the skeleton argument, which from memory is paragraph 67 and 68. So this is a preview of more to come, and obviously this video will be split into several, but the first of those paragraphs, 67, the conclusions bolstered by the fact that on occasion the judge sought to improve Amber Heard's evidence. Now, just before I go into this and explain it, the judge's job is not to improve or to embellish or to fill in bits of evidence. Going back to our example of somebody being pushed in the lake. Someone walking past a lake on a CCTV and then having said they've been pushed in the lake are together not evidence that they've been pushed in the lake. The third person who says that he or she saw them being pushed into the lake would be evidence of the same. A judge's job is not to fill in the blanks. A judge's job is not to enhance the evidence. A judge's job is not to make assumptions, is not to draw inferences that go beyond the evidence. The finding of fact must be based on reasoned evidence. So moving back to this document with these two examples here, which I find astounding that resulted in refusal of permission to appeal. But here we go. Paragraph 67. In relation to incident 12, the judge found that Miss Heard also saw probably nurse practitioner Monroe Tinker in Dr. Kipper's office on the 17th of December. I do not attribute significance to the comment by Miss Heard that she bumped her head accidentally while standing up. And for emphasis, it is underlined, she had not at that stage decided to go public with her allegations against Mr. Depp. Now, as noted here in this paragraph, these notes were not put to Miss Heard in cross-examination. So that cannot reflect the evidence. So, pausing for a minute there, the note and the comment here that she had not yet decided to go public with these allegations was not put to her, so it cannot reflect the evidence. And so this ultimately argues that the judge, the trial judge, had sought, as these grounds of appeal put it, as the skeleton argument puts it, to improve Amber Heard's evidence. And in doing so, which is not the judge's job, in improving that evidence, could then lead to a finding of fact, a conclusion, which ultimately went against Johnny Depp. And there are other examples. In this video, I'm going to show you two from this skeleton argument and then move back to the grounds of appeal. And as I say, it will be expanded into further videos. But moving back to the skeleton argument for a moment. In the second part of paragraph 67, similarly, The judge did the same in respect of incident 14. Incident 14 being that with the phone incident where it was alleged that she was hit in the face with the phone, and there were 2 photographs now infamously shown to have been edited with additional metadata and so on. The judge's comment here, underlined for emphasis. Since she was not willing at these stages to go public with her allegations against Mr. Depp, one purpose of the makeup would have been to do her best to conceal the injuries and marks. And again, it's noted that was not referred to in Miss Heard's evidence in relation to the incident. So just to explain that again, so that the meaning is not lost. Ultimately, the judge is saying here that Amber hadn't yet decided to go public. Therefore, one of the reasons for her makeup would have been to cover up the injuries. But this wasn't in her evidence. She hadn't said that she hadn't yet decided to go public, and therefore it cannot be a reasoned finding that she used makeup to cover up injuries. And yet this is what's referred to in this skeleton argument as a challenge to the judge's findings. So throughout the judgment, as I've picked in various videos, there are different elements and findings which are either extensively undermined and contradicted by the party's own witnesses and own accounts of events. Ultimately, it led in this skeleton argument, this grounds of appeal, and my view that this was a flawed judgment. So moving back to the grounds of appeal again, from paragraph 4, despite its length, the judgment lacks both analysis and reasoning for the trial judge's decisions to exclude matters which were damaging to or inconsistent with the evidence of the witnesses whose veracity or reliability the respondent's entire case depended, as I said, Amber Heard. So in other words, it argues that the judgment did not provide analysis or reasoning for the judge's decisions to exclude matters upon which the entire case was based from Amber Heard's evidence or credibility or reliability. And moving on, in view of the unreasoned, inconsistent and unsustainable findings of fact in the judgment, the appellant did not receive a fair trial in protection of his rights in accordance with both Article 6 and Article 8 of ECHR, which I'll come back to and explain another time. They are ultimately the right to a fair trial and the right to a private and family life. Where allegations of serious criminal conduct are determined by a single judge, the importance of an effective appeal process is far greater. This standalone sentence is equally important because appeals are difficult. Appeals are rare. Permission to appeal is not easily nor often granted. But this emphasizes the point that allegations of serious criminal conduct, which is ultimately what Amber Heard's allegations were against Johnny Depp, where they are determined by a single judge, the importance of an effective appeal process is far greater. This is precisely why I have said a number of times that this should have been heard by a jury, because the nature of the allegations underpinning the entirety of the case against Johnny Depp were of a serious and criminal nature, and yet it was heard by a single judge. If it were determined by a jury, I believe, it is my view, that the outcome would have been different. And that is borne out by the very fact that the Virginia trial with, I suggest, was the effective opponent, Amber Heard, resulted in the unanimous verdict that it did. Moving back to the grounds of appeal just briefly once more. Further, these findings have been reached in a judgment that has been widely publicised not only devastating to Johnny Depp, but wider repercussions for alleged victims or those who are wrongly accused of domestic violence. And this, again, is a point that I have said is absolutely paramount and one of the fundamental reasons I have been talking about this trial, because I have represented people wrongly accused, and high profile or not, because this was a high profile trial, it was all the more important. Why? You say, because being high profile, more people would hear about it. And this is important for so many reasons, because ordinarily these trials are private. They are heard in private. The family courts are private. Most of these type of allegations of this nature are in family courts, unless of course they make their way to the criminal courts. But even then, without a public profile, they may not be as widely publicized as they would be here with Johnny Depp. But certainly in the family courts, they are private trials. People do not hear about them. They do not hear the evidence. They're not permitted in the courtroom. Members of the public are not permitted into private family hearings. And yet these allegations are made and turn people's lives upside down. That is one of the fundamental reasons I've been talking about this, and it appears in the grounds of appeal. Finally, this is therefore a paradigm example of a case where there are additionally compelling grounds for the judgment to be reviewed on appeal in any event, but particularly given the weight of reasons which render the findings that the trial judge reached plainly wrong and unsafe. And then it goes on to the full grounds of appeal. So that was just the nature of the application for permission to appeal. And so this is the first of this video series. If you like this analysis of this appeal journey, which was ultimately refused, which I suggest has been corrected, at least in the court of public opinion, but I suggest needs to be corrected in the history books of the UK justice system. To that end, I invite you, if you would, to sign my petition, which is linked in the description, and in fact linked in the description of most of these videos. And as I say, this is the first video, so please do subscribe, please do hit the bell icon, add this to watch later, give YouTube all the signals that you want to see the next videos. I will try to keep them to around about 20 minutes or less for each installment, so that you're not watching for far too long. But I thank you for your time in watching. I thank you for your interest in this case and the wider issues in general. Please do subscribe, and I'll see you for the next installment.